Let's conclude our discussion of Chapter 8 with more discussion of crimes against public decency. Child pornography is another category of expression that lacks First Amendment protection. In the last lecture, we talked about obscenity. Obscenity is a separate category, so sexual materials that are obscene may be prohibited, but those mainly are materials that deal with adults. Because of the special harm to children that we don't find necessarily with adults, the Supreme Court has recognized another category of prohibited expression: sexual materials that involve children. And so any kind of sexual expression that features a child. So these could be things that these expression that could be legal, that would be legal if they were performed with an adult, such as simple nudity, so no sexual acts, but just nudity. These things can be prohibited because of the special vulnerability of children. And so the Supreme Court has carved out this category of child pornography from the First Amendment and said that child pornography is not protected expression. If these are sexual materials featuring children, then they can be prohibited, even if they're not obscene. So again, we don't have to apply the Miller test to child pornography. The fact that these sexual materials feature children is enough to put them in a category of child pornography and to allow the state to prohibit them, and to punish anyone who's in possession of them or who manufactures them, who distributes them, any of these kinds of things. So again, the expression could be perfectly legal if it featured adults. So again, simple nudity would be perfectly legal if the person is over 18. That would be protected speech. It's not going to be simple nudity. Posing in Playboy is never going to be considered obscene if it features adults. But if this person is under 18, then that would be construed as child pornography and could be punished. There's no First Amendment protection for child pornography. Because of some recent Supreme Court opinions over the last couple decades, the Supreme Court has defined child pornography as featuring actual children. And it must be that you're featuring them with the intent to arouse someone's sexual desire. So if you are a parent and you take a picture of your baby on a bearskin rug, a picture that parents may have taken, numerous parents have taken. You may have one. Your family may have taken one where you've done something cute and you have no clothes on and you were only 1 or 2 years old or whatever it was. That will not be child pornography. Okay, simply taking a picture of a child in that kind of innocent way would not be child pornography. It must be with the intent to arouse. So if you've got a collection of those pictures, even if they were innocently taken, but you collected them and you put them together and you kept them so that you could be sexually aroused by them, or you sold them to other people to be aroused, then that could be child pornography. But a parent who simply takes a picture of their child lying on a bearskin rug with no clothes on, that would not be child pornography unless we could show that that person had the specific intent of using these materials for sexual purposes. Supreme Court has also said that child pornography does not include young-looking adults or cyber children. So what we mean by cyber children are fictitious children who've been created through a computer graphics program or something. So these aren't actual children. These are just images of fictitious children that you've created on your computer. Maybe you've even just photoshopped a face of a child onto an adult's body, whatever it may be. Or with young looking adults, this is someone who is maybe 18, 19, 20 years old, but they appear in an X-rated film, and the film portrays them as a teenager who's under 18. So, as a schoolgirl, but they're really 18, but they're made to look like they're 14 or 13 or whatever. Those individuals, so whether they're young-looking adults or cyber children, if it's pornography that features those, that will not be considered child pornography. There was a case before the Supreme Court that featured a federal law that defined child pornography as featuring actual children, featuring young-looking adults, and featuring cyber children. But the Supreme Court struck down the provisions that dealt with young-looking adults and cyber children and said that these were either too vague or those individuals had the right. So someone who's 18 but looks 14 has the right to appear in pornography. And so we're not going to limit their rights by saying this is child pornography because you're trying to portray them as a child. The court said this is either too vague, this is too subjective, or again, it infringes on the valid rights of adults. So as it stands now, the only thing that will constitute child pornography is if the pornography features an actual child. If it features a young-looking adult or a cyber child, it will not be child pornography. Throughout our history, we've punished certain consensual sexual acts. So again, these are consensual. These are not forced. These are, and we're only talking about between adults. So let's leave sex with minors out of it for right now. But we've punished consensual sexual acts between adults. So there's been a time in our history when we've punished oral and anal sex between adults in private. So as long as it wasn't so we're not talking about prostitution, but this is two consenting adults. Maybe they're married. Maybe they've been married for 40 years. At times in our history, it has been illegal for even married adults to have oral or anal sex in the privacy of their own bedroom. In the 1970s, many states began to decriminalize this behavior. For instance, Pennsylvania said that their statute that prohibited oral and anal sex between consenting adults was unconstitutional under the Pennsylvania Constitution. They said that in 1980. So again, 1970s, 1980s, through the 1990s, many states eventually said, we have no business being in people's bedrooms. We're going to declare these laws unconstitutional, or we're going to repeal them. However, the U.S. Supreme Court said that at least as these laws applied to homosexuals, that in 1986 the Supreme Court said the states could still prohibit oral and anal sex between homosexuals. They didn't tell us whether they would apply this same kind of reasoning to heterosexuals. So in the case of Bowers versus Hardwick, the U.S. Supreme Court said there was no constitutional protection for homosexual sodomy, oral or anal sex, between consenting adults. That a state could, if it detected such behavior, so if it found people engaging in private, in their bedrooms, in oral or anal sex, and it was individuals who were homosexual, the state could punish that behavior. In 2003, the Supreme Court reversed itself. In a case out of Texas, the Supreme Court said it was wrong in Bowers versus Hardwick that the right to privacy does protect private consensual sodomy, whether it's being done by heterosexuals or homosexuals. This behavior is now protected. So it overturned Bowers versus Hardwick. So the current law is throughout the entire United States, private consensual oral and anal sex is now protected under the right to privacy. So as long as it's not prostitution, as long as it's not being forced, as long as it's not featuring minors, as long as it's in private, so it's not on the public streets, this behavior is protected under the right to privacy. States cannot prohibit it. So oral and anal sex are now protected under the right to privacy, again, as long as they're private, not prostitution, not coerced, but consensual, private, and for non-commercial purposes. Finally, there are many different offenses that dealt with sex that are no longer prohibited anymore. The These include seduction, fornication, and adultery. I also have bigamy listed here, but bigamy is still prohibited. So let's go through each of these just very briefly. Seduction was an old law that said that it was illegal to obtain sex through some fraudulent promise to marry. So if, this was usually a man seducing a woman. So if a man came up to a woman and said, I will marry you, but first let's have sex. And if that woman believed that this man really intended to marry her and she consented to the sex, but then he didn't marry her and he had really no honest intentions of marrying her, he was just lying to her to get the sex, then he could be charged with seduction. Again, this statute is no longer on the books anywhere. Seduction is not a crime. Fornication was sex between unmarried people. So these were two single people who had sex with each other. This was outlawed by various statutes that were under the title of fornication. They were called fornication statutes. Again, this is no longer against the law in any American jurisdiction. So sex between unmarried people is not, as long as it's consensual, as long as it's featuring adults, will not be considered fornication. Adultery was similar to fornication, except at least one of the people who was involved in the sex was married to someone else. So this involved cheating. So both of the people could have been married, but they weren't married to each other. But at least one of them had to be married. So we could have a combination where both of them were married, but they were married to different people. They were cheating on their spouses. Or we could have a situation where one person was married and the other person that they were having sex with was single. This was adultery. Either way. So this was sex outside of marriage with at least one of the people involved being married to someone else. Again, this is no longer a crime. Finally, bigamy is the crime of being married to more than one person at the same time. This is still prohibited in the United States. Other countries may allow it, but in the United States, you're obviously only allowed to be married to one person at a time. You can get divorced and remarry, obviously, but you can't be married to more than one person at any given time. You can cohabitate with several people as long as you're not married to each and every one of them. So one spouse, that's it. So again, except for bigamy, all these other behaviors, seduction, fornication, adultery, are no longer illegal.